Good morning, everyone. Good morning. Good morning, Instagram. Good morning, YouTube. Good morning, Facebook. I'm just going to let you guys trickle on in. How's everyone doing? How was your weekend? Comment in the box. Let me know where you're tuning in from. If this is your first time, definitely comment in the box so I can say hello. I'll give you a shout out. Hello, Strictly Business. Thanks for tuning in. Patton on Instagram. Good morning. Young Jyrons, good morning. Gillybat, good morning. Sophia, good morning. From Los Angeles, that's super early right now. It's like, what, 7 o'clock? Okay, let me introduce myself. My name is Aisha Chidole. I'm an immigration lawyer here in Atlanta, Georgia, and I represent clients all over the U.S. with their humanitarian-based immigration cases, family-based immigration cases. Your location is not a problem. We represent clients in all 50 states and internationally, as long as you want to adjust your status or get a green card to the United States or file for citizenship within the United States. If you want to schedule a consult with me, my number here is 407-995-6567. You can also send a WhatsApp to 404-333-8751. Hi, Bushalami and Popsy from New Jersey. So today I have a really good topic, in light of this weekend, if you haven't seen that post, I had posted this Saturday about one of our clients that I was just really, really excited about because, that client really came to us hopeless, and was just trying to figure out what they were going to do because, they were getting divorced, even if they stayed in the abusive marriage, like they couldn't adjust their status because of how they entered into the country. And so we had to basically go through several process of elimination questions to determine what the person would be eligible for. And that's why, as an attorney and, something that, every other attorney that works at my firm understands is that when we have people that schedule a consultation, we really do our best to try to screen you for different reliefs to make sure that, even if you're not eligible for one, that we've exhausted all the options to see, if there's something else that you may be eligible for that we've not screened you for yet. So let's talk about, first of all, what is an adjustment of status? I know people get confused with adjustment of status and consular processing. So let me explain the two. The two basically can result in a green card. Adjustment of status can only happen while you're in the United States. That's essentially what it means. It means that you're already in the United States, you're in one status in the United States, and you want to adjust to become a green card holder. So that's the only reference when you're in the United States. So when they say adjustment of status, that is something that has to take place while you are in the United States. So you can adjust your status while you're outside of the United States. It's only when you are in the United States. And then, consular processing means that you can apply for a green card from outside the United States. You have to be outside the United States to apply for the green card. There are certain things that you need to meet in order for you to be eligible for adjusting your status. I'm going to talk about the ones with just really hard stances, not the ones that are debatable or arguable or negotiable, but the ones that there's literally no other way for you to adjust your status. So let's talk about the first one, which is probably the one that most of you know, when you enter into the United States without inspection. So what does it mean entering into the United States without inspection? What that essentially means is that, you came into the U.S. without inspection at the airport, without inspection on the land border, without inspection on the sea border, meaning you snuck into the country and there was essentially no documentation for you, okay? If you entered into the country, we call that EWI, which means entry without inspection. So if you enter the country that way, if you get married to a U.S. citizen, and apply for a green card to adjust your status, you're not going to be eligible to adjust your status because there is a bar on adjustment based on marriage if you enter into the country that way. Now, there are always exceptions to every rule, which we can, I'll get into in a second, but I'm specifically talking about if you want to adjust your status either through marriage or through your parent being a US citizen or your child being a US citizen and over the age of 21. In that instance, one of the few exceptions amongst three others or four others, I would say, in order for you to adjust your status would be one, if you qualify to file for a VAWA application. That's number one. Number two, if you qualify to do what we call a T visa. Number three, you qualify to do a U visa. So those would be the only times where you may be eligible for adjustment based on something else that you have to be approved for before you can get there, inclusive of one other one that I mentioned. I remember to mention was like asylum. Okay. Now, if you are married, so in those cases, if you're not eligible for adjustment of status, you have to do what we call consular processing. And in order for you to do consular processing, you first of all have to get your I-130 approved. And when your I-130 is approved, then your U.S. citizen qualifying relative needs to get approved. Well, you need to get approved of a hardship waiver, but you have to show hardship to your U.S. citizen qualifying relative, which usually is very limited. For most cases like this, the qualifying relatives would be a parent or a spouse that's a U.S. citizen or a green card holder, not children, a parent or a spouse. Again, I will go down the rabbit hole about talking about different kinds of cases and what might be the qualifying relative or whatever, but I'm just specifically talking about a basic adjustment of status case based on you just being married or you filing because your parent is a U.S. citizen or your child is a U.S. citizen over the age of 21. Okay. So that's one. The second option where you cannot adjust your status is if you are married to a legal permanent resident, meaning you are married to a green card holder and visas are not available and you have overstayed your time. Overstaying your time means that you entered into the country with a visa and you were given a stamp to stay here for 6 months. It's not the same as, because sometimes when I ask somebody and I say, how long, when did you enter into the country? And they're like, oh, I have a 10-year visa. Having a 10-year visa doesn't stop you from overstaying. Most people are going to get a maximum of 6 months entry stamp when they come into the United States, right? Unless, let's say you're coming here like for a student visa or something like that, where you get a duration of stay, meaning when the program is over. So if you get a 6, or some people will get less depending on how, they've been entering the country. But basically your I-94 states when you can be in this country. So if you've overstayed, let's just assume for ease that it's 6 months. So if you've overstayed more than 6 months and you want to try and do an adjustment of status with your green card holder spouse, you will not be eligible to adjust your status. You will also need to do a hardship waiver. Earlier last year, and basically from the end of 2019 through September of last year, you could have adjusted your status if you were married to a green card holder, if you're within status. But because the visa bulletin changes every month, the visa bulletin changed, and it's not looking like it's going to adjust anytime soon, it means that, unfortunately, you're most likely going to be out of status and you will not be able to adjust your status. Again, the exceptions to the rule would be, if you're a VAWA applicant and you get approved from VAWA, T visa, U visa, and things like that. Okay. Another area where you cannot adjust your status, and of course there's certain exceptions, is if you are technically, you can adjust your status through court if you have something that makes you eligible. But let's say, like you filed for asylum or something like that, and they basically denied your asylum, and you're in removal proceeding or ordered you removed or something like that. You cannot just adjust your status with USCIS. We usually will need to show that, one, there's a new benefit that you're eligible for that allows you to be here in the United States, that allows you to adjust your status here in the United States, and that we can request from the government, DHS, for what we call prosecutorial discretion. Okay? Prosecutorial discretion basically stating that, this is a waste of the court's resources putting this person on trial when this person has like a spouse who can file for them, So that's another option. And then for those of you who come here with a J1 visa, you always want to look at your visa. Does your waiver have your waiver have a 2-year exception? Meaning, so some J1s, the waiver will basically say you have a 2-year residency requirement, which means you can adjust your status until you go back to your home country for 2 years. Now, if it says that, you can certainly try to request a no objection waiver through your country and consulate, basically stating, they don't object to you, adjusting your status. But until you do that, you cannot adjust your status. So these are, there's so many other different things, but these are the core ones that you're going to find from a day-to-day basis. And then the one that I talked about in my video, where if you enter into the country on a C or D visa, so that's like a crewman visa. So think about it this way: people who enter to work on a cruise ship, so if you're working on a cruise ship, they can give you a C visa, D visa, like a crewman visa. In those cases, you cannot adjust your status because you're not supposed to be in the United States. It's kind of like a transit visa to allow you to be on the crew, on the cruise or in the crew of the ship or whatever. So in those cases too, the only exception would be if you qualified for VAWA. So in speaking about my client who I posted about this weekend, sorry guys, I'm being interrupted because I have one very good news for somebody on here that I see just commented. I'm going to call you when I finish this because I don't think you even know that we got your 10-year green card, but I'm going to call you when we finish. Anyway, going back to what I was saying. So like for this particular client, so not only did they have a crewman visa, that was one whammy. They had the second double whammy. They were married to a green card holder. And then the third one, of course, that person was trying to divorce them. So, by the time the person came to me, they were like all out of luck and really believed that this was the end and they were going to have to go back, but in screening that person, we were able to determine that that person qualified for VAWA. And, after 15 years of being here and just kind of like going through the cycle, trying to figure out, and that person got their 10-year green card on Saturday. So very, very exciting news. Someone's asking where we're located. We're here in Atlanta, Georgia, but we represent clients all over US. So location is not a problem. So I think those are the core ones that I wanted to talk about. I'm just going to take some questions. Let's see. This person's like, what about people that are looking about citizenship, but because they did not sign by the child's mother, that is, that they are taking care of their child, they denied him citizenship. How do we go about it? So that's a really good question. For those of you who don't know, USCIS takes child care and taking care of your children and child support very seriously. So essentially, if you, basically have not taken care of your child, and this is for both men and women, by the way, if you don't have proof that you take care of your child financially, they will deny you for U.S. citizenship. So in this case, even if the mother is not willing to sign something, Arlene, does this person have proof that they take care of their child? So and this is for those of you on here who have that situation and, at some point want to file for naturalization, especially if you don't have a child custody or child, custody agreement, or child support agreement. You want to document every time that you were sent that you send money. You want to document that. I've been in an interview where we basically got an affidavit from the spouse because he didn't document it, and USCIS, not the spouse, one of the baby mothers, and USCIS officer called right there in the interview, said, "Okay, let's call her and see if you know, pay child support." And she was able to confirm that he did. So it's really important that you're documenting every time that you send money to your child so that you can have that as proof if you don't have a child support agreement. So that's what he's going to need to do. Okay. Christiana Akia says, "Good morning. My vow was approved. Yay. And I filed for a fee waiver for the green card for me and my children, which was approved 3 weeks ago. How many more months for the green card to be approved?" Can't really say, timeline, depending on when you filed, because I don't know if you filed when you submitted your VAWA or you filed after you submitted your VAWA, because that's going to change the timeline. Okay. All right, let me go to Instagram. Oh my gosh, I don't know if I can catch up with all these questions. Good morning from the Big Apple. Yes, good morning. Let me see. Hi from Israel. Ikechukwu, good morning. I don't handle EB2, so there's no point of me talking about it because I won't be able to help you with that. But if you go to, her name is Carol Williams of Williams Immigration. She handles employment-based, investment-based green cards. So, that's who I would say you should contact. Can a citizen or a green card holder parent file for their child that's married and above 26 years old? So a green card holder parent cannot file for any married son or daughter. They're not eligible. However, a U.S. citizen parent can file for a child, a son or daughter that is married or unmarried that's above 26. The only difference is that you're going to see a longer wait time. If the child was under 21, that would be considered an immediate relative, so you don't have to waste time. You can file and go through the normal process. But once you go over 21, then you're subject to the visa bulletin, which can take anywhere from like 6 to 9, 10 years, depending on what country you're from and what the visa bulletin says on the month when you submit your application. How long does it take to get a receipt after sending a VAW application? It used to be much quicker, like 4 to 6 weeks. Now we're seeing anywhere from like 8 to 12 weeks for receipts, and even longer if you are not submitting an adjustment of status application with it. But if you just sent it 3 weeks ago, it's fine. You should be getting it, but make sure that it's late now, but hopefully you did like a proof of delivery, so you know that it was in fact delivered to the right address. Can I withdraw an appeal and refile after remarriage? You can. Can you have two I-485 petitions running parallel? No, you cannot. Other different kinds of cases that you can have running parallel, but you can only have one I-485. So one of them is going to be denied. So, just pick whichever one that, gives you a better chance. And then, you can withdraw the other one. Is it possible to be approved for a green card if you have an H-2B work permit? Yes, but something has to make it eligible for the green card. You can't just go from an H-2B to a green card if that's what you're asking, like meaning your H-2B cannot qualify you for a green card. However, if there are other categories of stuff that makes you eligible for a green card, you certainly can get a green card. Can a green card holder invite a parent, meaning just for like a visitor's visa? If that's the question, sure. It's really up to USCIS to not USCIS, really the consulate, to decide if the person has a sufficient nexus to return back home. Sometimes they don't even look at the invitation letters, but you certainly can. Please talk about annulment and divorce. What area? What do you want me to talk about in particular about them? If you can give me like a scenario, then I'll be able to talk about them. Are you talking about in context of removal of condition or in valid cases? I mean, with annulment and divorce, you can do a regular marriage adjustment of status. So it depends on what you're asking. And then it also depends on, who's filing the annulment and what's the basis of it. Um, how soon will the new immigration fee changes become effective? We really don't know. We really don't know. We're still kind of like waiting to see if it happens or doesn't happen. The premium processing fees that change, those ones are for like really employment-based immigration. So there's no point of me talking about that just because I don't represent employment cases. Dave McPherson says, please save this video. I will save it so you can always go back to it. Okay. How long does the process for a fiancé visa take for a gay couple? It takes the same time. There's no difference between that or same-sex versus heterosexual couple. You're still within the same timeline, and the answer to that is going to depend on the country you're from and what the backlog is with the country. But I would say, like, for a fiancé visa, it could be anywhere from 12 to like 18 months. It just depends on the country. Do you only do VAD cases? No, we do other kinds of cases, but we have a very strong presence and representation for VAWA applicants, but we certainly do all types of family immigration cases and humanitarian-based cases. Jay sure says, congrats to that person who got their 10-year green card. I know, right? Very exciting. I have two people actually that I have to give good news to today. If you have an F1 visa, but you couldn't show up in school and your visa has expired, can you adjust your status? It's going to depend on if USCIS has determined that it was misrepresentation and you never had the intention of going to school. So I would need a little bit more to be able to say, you may need like a misrepresentation waiver. It just all depends. To repeat my number again, it is 407-995-6567. You can also send a WhatsApp to 404-333-8751. My number is literally scrolling through the ticker. When I get off this live, it is on my Instagram profile right there. So you should be able to see it right there once I get off this live. Follow me if you don't so that you can see it. Okay. How many months does it take to approve filing for parents? Parent filing without any issues usually are very quick. It could take anywhere from like 4 months to 12 months. So it just depends. Tasha Blue says, I need to talk to you. Call me. Call the office. Let's see. Do you handle immigration cases in Canada? No, we only represent those who want to immigrate to the United States. I'm an asylee and I applied for adjustment of status. My work permit is expired and my driver's license is as well. Do I have to renew my work permit? Absolutely. You should renew your work permit and always renew it until you actually get your green card. If you're denied an I-485 because of your sponsor's qualification, is it okay to file again? Absolutely. You can always file again and just make sure this time you have the right sponsor and the sponsor meets the income requirement and can actually document and show they meet the income requirement. I'm just going to take this last question on Facebook, then I got to go. I did my biometrics in August. And I still haven't heard anything. This is too vague a question. I don't know what your case is because there's biometrics for all cases. So I'm not really sure what it is. Yeah, so I can't really answer that question. If I didn't get to your question live, I'm going to be on tomorrow at 10 Eastern Standard Time. So definitely come on and ask your question. If you want a confidential consultation, call me, call the office, 407-995-6567. All right, guys, I will see you tomorrow. Have a great day. Bye.